Thank you very much, John. I appreciate it. Speaking of judges, and boy, does that what a great transition that is. Judges on the Fifth Circuit Court of Appeals, typically a conservative court, came down with an inexplicable ruling yesterday. I'm going to go over it with our legal eagle here on the Chris Salcedo Show, Byron Henry. He's an appellate law expert with the law firm Scheef Stone up in Dallas, Texas. Hey, Byron, thank you for holding. Appreciate it.
No problem, Chris. Glad to be here.
So you and I talked yesterday when I booked you on the program after this ruling came down, and you and I bandied back and forth about what it actually says. I think Fox News had the most fair headline. A lot of folks said that our voter ID law was struck down, but Fox News says, well, wait a minute, the court instructed changes to be made to the current law.
That's right, Chris. In fact, the law was not struck down. The opinion specifically says that the law should be enforced for the 90% plus Texans that have voting Texans that have IDs. What they said was, because there is a small percentage, and the court noted, the dissent especially noted, that about the same number of white voters don't have voter ID as black and Hispanic voters combined. So how they found that it's somehow discriminatory when about the same number of white voters don't have, are poor and don't have ID as minorities is a little bit bizarre. But that notwithstanding, the court basically said you need another out for the small percentage of poor or minority or white, whoever the voters are, that do not have this voter ID and cannot get access to it for whatever reason. And we don't know what those reasons are, because Texas has made the actual election ID card free. They've also made getting a birth certificate for purposes of getting an election ID card free. So, but for whatever reason, people...
That begs the question. Isn't it incumbent upon the court to tell the state of Texas that how it's violating the rights of some of these people? I mean, if you're going to say change it, it's violating their rights, isn't it incumbent upon the court to say how are those rights being violated again?
Well, I use this word because as I was reading the 203-page opinion, which included all the opinions of the dissent and the concurrences and the majority opinion, it was basically, it somehow is discriminatory because of those that don't have voter ID, they're mainly poor. A higher percentage, not a higher number, are African American and Hispanics, and it's too difficult for them. They're either, and this is very denigrating on the part of the court, they're either incapable of obtaining ID, or they're too poor to obtain ID, and the state has to make it easier for them. I don't know if they have to actually provide transportation to the DMV or come to their house for them to give them voter IDs or to allow them to sign up. But basically, it's a lot like the abortion case, where the court found that it was an obstacle to get an abortion because some women would have to drive, more than a couple hours to obtain an abortion one way. In this case, it really comes down to, there was even a line in the opinion that says a higher percentage of minorities use public transportation, therefore it's more difficult for them to get to DMV offices. So I think it really comes down to the legislature needs to make it slightly easier, and what they're trying to get the legislature to do is to change the law and allow people to vote at the polls by simply signing a form saying, I can vote, or an affidavit of some sort. So it really comes down to a very narrow ruling that says for the few people that don't have IDs in the state of Texas and can't get one, by the way, not just don't have them, but can't get one, you need to sign something at the polls and make it available for them to vote a little bit easier than you've currently made it. And although I think,
did the court
they've made it pretty easy.
As you mentioned, an equal number of whites who don't have voter ID equals that of blacks and Hispanics combined. Did the court find that it was discriminatory against the white people too?
Well, no, because it's percentage. Even though the number is the same, it's about 2-point-something%, I believe the opinion said, of whites, and a higher number in the 6 to 8% for African Americans and the 5 or 6%. So basically, it's triple the percentage of African Americans and double the percentage of whites for Hispanics, but it's about the same number, of course, because the white voters, outnumber.
Well, wait a minute. So discriminating against 2% of the white population is cool? Is that what the court has determined? That's cool?
Well, the Voting Rights Act, which is what they ruled on, not the Constitution, has a disparate impact provision on minorities. So the Voting Rights Act was specifically passed to protect minority voting rights, so that's the way the court addressed the problem.
I find this insulting. You know what? The Fifth Circuit Court of Appeals basically said people with my type of surname, Latino surname, and my skin color, and those in the black community are too stupid to obtain a free ID from the state. That's basically tantamount what they've just said.
Well, if they didn't say they were incapable of doing it, they certainly said that they didn't have the funds to somehow make their way to a DMV office in the time frame provided by the law and follow the simple requirements to obtain one. And the issue, the court, and the court also took Texas to task, which is also bizarre, about its past. Its discriminatory past. And in the first part of the opinion, basically chided the lower court by blaming Texas for saying that Texas did not pass the law with a discriminatory purpose. They didn't intend, purposefully discriminate against minorities. But then the second part of the opinion used all the same evidence to show that it's basically the state of Texas's and prior legislature's fault that African Americans and minorities can't afford IDs because of the situations created by the state of Texas. So
that's absurd, because there is no greater opportunity in this country for jobs, for upward mobility, for housing than in the state of Texas. And the Fifth Circuit, I think, has lost their mind. That is an insane opinion.
As I said, I've used the word twice before. I'll use it one more time. Reading the opinion was bizarre. It's basically that Texas didn't intend to discriminate, but basically its history is discriminatory, even though they couldn't cite any instances of discrimination. Their most recent instance that they used was 40-some-odd years old. And in one point, the dissent actually made the interesting point that the majority is actually using past legislatures against the current legislature, even though some of the past legislatures they cited were controlled by the Democratic Party, and the current legislature is Republican, which the dissent found very enigmatic, that you could use something that the other party did in the past 40 years ago to hold the current legislature responsible. So, as I said, it was an odd read. I think that there's an easy fix. The legislature won't meet to fix it. It will have to be done by judicial. The state will have to get with the other side and craft an exception that the court will accept for this election. But this issue's not over, and the Court of Appeals made clear that this case will continue past this November's election.
Byron Henry, everybody, appellate law expert with the law firm Scheef Stone up there in Dallas. Sir, appreciate you. When we get on the Dallas show later today, you and I will talk again, okay?
Sounds good. My pleasure.
Thank you, Byron. Appreciate it. Good grief.